Shalom. Today this is for the record part 8, and I have to report the truth as I see it in righteousness. So it appears that Spectrum and Southern California Edison has acknowledged and accepted my right of being a sovereign man to discharge debt as a remedy, and I have to give them credit for that. So like I said, it appears, and as long as they remain amain or appear to show good faith in honoring my request, I have to acknowledge what appears to be honor on their behalf. That Spectrum had turned off my cable. I went in on yesterday, September the 26th. I went on yesterday on September 26th and spoke to one of their employees, and went in, and it appears that they turned my service back on, at my request per the remedy of discharge of the debt. And also I was given a 48-hour shut-off notice on the Southern California Edison bill. Also, I reached out to them, and it appears that they have responded in honor my stance as being a sovereign man on the land, and they've appeared to have discharged that debt, and my service is still on. So I have to give them credit for that. I reported the negative, now I'm reporting the good, what appears to be good. So I've also reached out to Waste Management, who I put out on record of their neglect and bad faith. So I've reached out to them. Hopefully they'll go ahead and correct that as well, and then I'll come back and post a positive message about them if they react in honor. Also, for the record, I want to also, for informational purposes, not telling anybody to follow my lead, but just sharing information. That's what this is all about, sharing information. And as I learn information and listen to others who provide information, whether good or bad, I listen to it all, because I try to get the good out of it. Out of, if there's any treasures or pearls in that message at all, I try to take that. So that's basically all I'm doing, is providing information. And if you find any good or treasure in it, you're welcome to utilize it. And like I said, this is just for information, educational purposes. What I presented, based on the knowledge that I've obtained to this point, I presented an affidavit of notice. And this is just for an example. I put this out to basically everyone that I'm going to interact with. And I'm just going to use this one for this purpose. Affidavit of notice of action of abatement at law of good faith quietus by Nikis Elagiyakadesh, secure party creditor and interest holder, being the executor over the estate, in all capital spelling Anthony Madrus Pooler Sr. and all of his derivatives. Dated the 25th day of the month of September of the year 2018. I am the living man, born alive, and I live where I am present because I am the state of being. I am sovereign man, established by Yah the Almighty Elohim, granted authority by Yeshua, Yah is salvation. I assert my granted sovereign authority over all corporate color of authority operating under the color of law, that which appears to have authority but is actually man-written laws of no effect unless I, one of the de jure American states, grant them authority, and I do not authorize a fictitious foreign company called the United States Company bankrupted since 1933 any authority over my body, my property, or my mind, or anything that is mine. The de facto president in that era and still valid today, named Franklin D. Roosevelt, signed and recorded the action under the color of law termed the Federal Reserve Act of 1933, creating legal fiction through the use of Federal Reserve notes, fiat notes, debt notes of no de jure value, not money, gold or silver coin, being in all actuality promissory notes, meaning promise to pay at a later date. The use of this promissory note in the economic system used by the United States company because of the bankruptcy filed in 1933, it is no longer considered a government. It has fallen to the state of mere corporation with no more authority than any other store, for example Walmart, according to the Clearfield Doctrine. I do not authorize the United States company or any of its agents or affiliates, being fictitious characters or actors, power of attorney over my estate or state of being, person, or inalienable rights. I do not agree nor contract to operate as a fictitious person called a straw man recognized on paper in this corporate world of imagination. I cast down imaginations as instructed by the word of Elohim Yah. I serve notice for public record that I cast down this imagination, and I am not held to the fictitious color of laws of the foreign corporation mentioned above. I serve notice. I am in full life, and when I do operate in this admiralty law of the sea, I shall cause to discharge all debt belonging to the United States company by the power of my signature and really my autograph, and original identification mark being my thumbprint, has been interpreted as authorization for agents of this United States company to discharge, set off, and charge off all debt associated with service, goods, and bills of credit. I do not consent to the trap and deception of being in agreement to classify myself as being a straw man, and I serve notice that I, the living man in full life, shall be recognized as Negus Eglage Yah Kadesh in proper English spelling, and in the event that these corporate agents or United States company attempt to use deceptive practices to entrap me in deceptive language and practice, such as using the name game, interchanging the different variations of the fictitious person named after the given name, Anthony Madrus Pooler, the senior, in proper spelling, English spelling, in which the United States company incorporated at a later date into all capital nomen name Anthony Madrus Pooler, straw man, in all capital, and all of its variations for the deceptive practice of connecting me, the living man, to the District of Columbia and all of its association through the use of their birth certificate, driver license, in manner, their zip codes, in an attempt to trap me into being a citizen of a de facto foreign bankrupt company acting in dishonor under the color of authority and color of a law since 1933, in which the bankruptcy was official and the U.S. And the use of Federal Reserve notes were implemented by then their president, Franklin D. Roosevelt. I authorize all of my posts to be delivered to care of 3004 Hildreth Court, Lancaster, California, for the post delivery, and I do not want any free service to link me to servitude to this fictitious system. I choose to utilize the remedy in this matter by discharging all debt charged to the United States and all its derivatives. 12 U.S. Code Section 411, 12 U.S. Code Section 411, issuance to reserve banks, nature of obligation redemption. Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to the Federal Reserve Bank through the Federal Reserve agents as hereafter set for and for no other purpose are authorized. The said notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks, and for all taxes, customs, and other public dues. They shall be redeemed in lawful money on demand at the Treasury Department of the Federal Reserve Bank. And he goes on to all these stats, and you can, go into all these stats. I serve notice of remedial action, that which affords a remedy, as a remedial statute, or one which is made to supply some defects or abridge some superfluities of the common law. Remedy: I authorize the United States Company and all of its utility companies and debt collection agencies to discharge, set off, and or charge off all associated debt belonging to the United States Company for the balance of these corporate entities' accounting books of record. I serve this notice of action of my intent to utilize those coupons notes sent by the utility companies, merchants, or collection agencies as accepted for value for payment for goods and services in the course of trade. Coupons to payments, also termed remittance. See Bill of Credit. It is provided by the Constitution of the United States, Article 1, Section 10, that no state shall emit bills of credit or make anything but gold or silver coin a tender in payment or debt. Such bills of credit are declared to mean promissory notes or bills issued exclusively on the credit of the state, and for the payment of which the faith of the state is only pledged. The prohibition, therefore, does not apply to those notes of state bank drawn on credit of a particular fund set apart for the purpose. See, you have an estate that is already set up to take care of these debts in your proper persona, being a man or woman, de jure man or woman, with the name spelled in proper English spelling, and that you've made your declaration to the de facto, in all of its variances, and also in public notice of who you are, that you are not lost at sea, nor are you dead, that you are alive, and you have claimed your estate. See SES-KQ Act 1666 for reference. Okay, I'm gonna cut off there, and I'll go into the next video. Will be part 9. This will be part 9.